Welcome, everyone. This is the joint briefing of Committee on Ways and Means and the Judiciary Committee. This information briefing is going to be covering the Judiciary first and then followed by the Attorney General's office. So please proceed. And you want to introduce all of these.
Morning, Vice Chair Moriwaki, members of the Committee on Ways and Means. Good morning, Chair Rhodes, Vice Chair Gabbard, members of the Committee on Judiciary. Brandon Kimura, Director of our Judiciary's Policy and Planning Department. With me today are the Administrative Director of the Courts, Rod Miley, the Deputy Administrative Director of the Courts, Dalen Heather, our directors of our other statewide Judiciary Administrative Departments, our Oahu Court Administrators, and other key Judiciary personnel. So good morning. Thank you for having us. Thank you for the opportunity to present an overview of the Judiciary's mission, functions, and FY25 supplemental budget requests. As you are aware, the Judiciary's mission as an independent branch of government is to administer justice as an impartial, efficient, and accessible manner in accordance with the law. Within the Judiciary structure, court operations include our courts of appeal and circuit, family, and district courts across the state. Our trial courts also operate specialty courts, such as Community Outreach Court and others. These programs are tailored to unique needs. Court operations also include the day-to-day efforts in other areas pursuant to our mission, such as efforts to enhance access to the justice system. We do this in a number of ways, and a few examples are listed on slide 2. Self-help centers and access to justice rooms, which have since 2011 led to the assistance of over 36,000 Hawaii residents at almost no cost to the state. Small claims online dispute resolution, which allows those without attorneys to initiate small claims cases valued at $5,000 or less online and outside of business hours. Since launching this in mid-2022, 58% have initiated their cases outside business hours, which demonstrates the value add. We also send e-reminders of upcoming hearings to those who sign up, including litigants, lawyers, and anyone interested in following a particular case. Before I turn to our FY 2025 budget requests, a few words on the Judiciary's response to the Maui wildfires. The Judiciary has a Lahaina District Court with 7 employees. All of our employees who are Lahaina residents lost their homes or remain unable to live in severely damaged homes. Like every other part of state government and our state, the fires across the island deeply impacted our employees. Nevertheless, one family court judge who lost their home returned to the bench later that week to serve the community that was desperately in need. Another family court judge who evacuated her home in upcountry Maui with her family and returned to a heavily damaged structure also resumed work immediately to, along with the Child Welfare Services and others, find safe and loving shelter for the foster children in Lahaina who had no place to live. She acted quickly in light of the extreme traumatic impact on the children and provided mental health resource information to children and families and to resource centers that sprang up after the fires and to other responders and stakeholders as well, and was recently recognized by the National Judicial College. Chief Justice was on the ground to meet with our employees and Maui attorneys, the Hawaii State Bar Association, Maui County Bar Association, Maui County Prosecutor's Office, Maui Office of the State Public Defender, Legal Aid Society of Hawaii, Volunteer Legal Society of Hawaii, Native Hawaiian Legal Corps, Domestic Violence Action Center, and others. Were coordinating and providing legal information and advice to many across Lahaina who relocated to West Maui and to those in upcountry in need of legal assistance. We assisted with broad community messaging, where and how to obtain legal assistance and other areas. To be clear, the types of support we have been focusing on are landlord-tenant matters, immigration, vital documents, probate, and other areas, not the litigation related to the potential causes, liability, or monetary damages of the fires that may come before our courts more directly. The Judiciary focused on supporting those on the grounds, providing assistance Chief Justice also issued orders extending deadlines as appropriate. And we ensured that our judges and others on Maui had up-to-date information regarding the governor's emergency orders pertaining to landlord-tenant law and others. The Lahaina District Court is located just outside the burn zone near the Lahaina Civic Center and in the complex with the fire station. It was not physically damaged in the fire, and for several weeks we lent it to emergency responders. It returned to full use as a court within months of the fires. Now turning to our budget, FY 2025 budget requests. Acknowledging that this is a second year of a biennium, a supplemental budget year, and the many uncertainties and factors presently impacting the Hawaii economy, the judiciary's operating request is for $3.24 million and 4.5 new permanent positions. This is an additional 1.75% to our FY 24 general fund appropriation. Our first request for FY 25 is for $1.19 million to cover a significant increase in electricity costs. Annual electricity usage has remained relatively stable for at least the last 6 years, and yet the price of electricity has gone up substantially in recent years. Electricity costs judiciary-wide have gone up approximately 37% since FY 19. Next is a request for $245,000 for a critical cybersecurity tool and monitoring services. This is for 24/7 monitoring to detect suspicious activity to allow for a quick response to any attacks. Next is $530,000 to increase compensation for court interpreters. To ensure those of limited English proficiency have meaningful access to the courts, professional court interpreters must have near native fluency in English and a non-English language, knowledge of the legal terminology and court procedure, and adhere to court interpreter code of ethics. They also must be skilled in 3 modes of interpretation: consecutive and simultaneous interpretation, and sight translation. Since the Judiciary's court interpreter program was established in 2007, the fee schedule has not been updated. Indeed, Act 248 of the last session, which was formerly Senate Bill 813, acknowledged the integral role of court interpreters and that an increase in the rates is overdue. Also in 2023, the Supreme Court Committee on Court Interpreters and Language Access Subcommittee on Interpreter Fees completed a study of appropriate fee schedule updates to ensure the program remains viable. Next is $170,000 to implement Act 159, which was Senate Bill 410 from last year, to modify the Judiciary Information Management System, or JIMS. Act 159 eliminates the requirement that a petitioner file with the court their expungement order and requires the court to seal all judiciary files once an expungement order is granted by the Department of the Attorney General. This will require modification to our case management system. Next is $137,000 for an Olelo Hawai'i operating budget. In 2022, the legislature provided funding to establish the Judiciary's Olelo Hawai'i program as a legislative add-on to our budget, which was folded in from Senate Bill 57 that year. We deeply appreciate this, and within a few months after passage, brought on an Olelo Hawai'i program administrator who has developed the course to train and certify Olelo Hawai'i court interpreters, begun to digitize documents in Hawaiian to make them public, begun to translate the names of our judiciary's divisions and offices and titles. And going forward, the program has prioritized translation, vocabulary development, establishment of a translator course, enhancement of court interpreter course, and updates to the website and signage. It currently has no operating budget. Next is $882,000 to restore funding for 14 positions that were defunded during the 2020 legislative session. Of these 14, 6 positions are in the First Circuit, 4 are in the Third Circuit, 1 position is in the Fifth Circuit, and 3 positions are in administration. The positions range from a district family judge on Kauai to a chief information security officer to a probation officer in the Hilo sex offender unit to Wahiawa document and judicial clerks and others. The next group of requests pertain to 4.5 new permanent FTE. Of these, 2 are for janitors at the new Wahiawa District Court. The funding request for these is for only half a year due to when the courthouse will be ready for occupancy. 0.5 is for a social worker 4 in the Office of the Public Guardian on Maui. Currently, the Office of the Public Guardian on Maui has only a 0.5 FTE. This request is important because of the impact of the Maui wildfires and how strained the Office of the Public Guardian has been statewide due to the additional needed coverage on Maui. The OPG director and other Oahu staff are overseeing all the cases on Maui and expect those numbers to increase following the wildfires. We are also requesting 2 no-cost conversions from temporary to permanent to bring more stability to 2 other positions and assist with attracting qualified candidates and ultimately retention. One of these is for workers' compensation in our HR department, and one is for a court operations specialist in our courts of appeal that would assist with maintaining these 2 buildings in our courts of appeal that are on the national and state historic registries list. And our Iolani Hale, where our Supreme Court sits, will turn 150 years old later this year. Now turning to capital improvement projects. This slide represents an overview. These capital improvements also remain a major item of concern for the judiciary as our facilities age. We are requesting a total of $17 million to fund CIP. 14 of this we're requesting in bond funds, and $3 million of this in operating funds for reason I'll describe in a moment. I'll describe each of these 5 requests in detail. Our highest priority CIP request is to continue phase elevator modernization project to ensure the safety of the public and employees. This phase includes upgrading the cabs and mechanical equipment of 4 obsolete elevators in the public area and installing air conditioning in the elevator machine rooms to control humidity and temperature in all the elevators in the building, which will extend the life of the equipment and minimize breakdowns. This is a very high priority for us and is needed to adequately protect the safety of the staff and the public. As indicated on this slide, elevators are down approximately 1/3 of the time. Over the prior year periods, there have been hundreds of trouble calls and dozens of entrapments. We've requested funding for this project since FY 2011, and the request this year is for $9.25 million. That'll cover the 4 elevators where the public and some staff use as well. Our next priority in CIP is to separate storm and basement level sanitary sewage system. The current combined storm and sanitary systems are in violation of the City and County of Honolulu ordinance and are a major health hazard, which contributes to severe flooding events and has resulted in damage to the building. This request is for $1.5 million. Next priority is the second and last of a 2-phase project at Ho'opili Hale on Maui, to build out a courtroom from an existing area that was previously used for file storage on the first floor to fulfill the need for an additional courtroom capacity. Currently, there are only 8 courtrooms for 9 judges. Having an additional courtroom will increase efficiency and help to timely address pending cases. The 4th request we have is for $2 million in lump sum bond funds to request to continue long-term improvements to extend the life of facilities that we occupy. And 5th is a request for $3 million lump sum in operating funds for the upkeep of judiciary facilities and address emergencies that may arise. The funding may be used for near-term repair and deferred maintenance projects of limited scope at facilities that we occupy. I'll acknowledge here that we've categorized this as CIP because it is indeed for capital improvements, and we're requesting operating funds nevertheless. Last session, legislature provided lump sum operating funds for CIP that is proving to be very helpful to address repair and maintenance issues where we cannot use bond funds. For example, we will be using those funding for, among other things, rehabilitating inoperable cell doors at our Honolulu District Court building, repairing the skylights at Iolani Hale. And this concludes my presentation. Thank you for the opportunity to provide you with a briefing today, and we're available to answer any questions you may have.
Next question, Senator Kidai.
Thank you, Chair. You mentioned that this year the Judiciary building will turn 150 years old. Are you guys planning a celebration? I did see any funding specifically for that.
The Judiciary History Center, which as part of its mission is charged with ensuring that the folks know of the public is aware of the wonders and beauty of the building, we'll be planning something, and I'm sure we'll be doing something else as well. But at this time, we're not requesting legislative funding for that.
Thank you.
Senator Chino.
Thank you. Well, first off, thank you for including in the budget the court interpreters. Long overdue.
Yes.
Thank you so much. With regards to the wildfire, it seems like in your budget, you had 3 investigators assisting with Maui County, pretty much in security detail over time. However, you have at the end a question that's FEMA reimbursing, FEMA eligible as well as FEMA reimbursement, but you have a question mark there. So are you going to get reimbursed, or is it coming from Maui's administration portion of their FEMA reimbursements? But are you going to be able to get the reimbursable?
Thank you for the question. We don't have that in our table. I'm not sure if that was in the Attorney General's or not.
Table 25.
I don't believe
Oh,
that was. in our table.
sorry. Maybe.
I don't believe that was in our
Yeah.
table.
Okay. That's AG's, I think.
Okay.
We'll deal with them.
Okay.
Yes.
I'm sorry.
Thank you so
Senator.
much.
Thank you,
Sorry
Senator.
about that.
Thanks for the presentation. Well, first big picture, the increases in the 882,000 that you mentioned before, does that bring us back in terms of personnel to levels that we were at before the pandemic?
It does not. We, during the pandemic, we were defunded, I believe, a little less than 200 positions. So last session, we sought restoration. The legislature graciously provided for some of those positions. This session, we're seeking for 14 more, but nowhere close to the full amount. And the reason we're seeking it relatively small batches at a time is so that we can work through those, make sure that we're prioritizing, redescribing as we need.
Okay. With regard to one specific position, cybersecurity, restoring the one full-time equivalent for Chief Information Security Officer. I'm looking at the salary numbers there. Is that actually competitive? I mean, can you hire anybody at that salary? I think it's 109,704.
Yeah, Senator, thank you very much for the question. This is an example where, and this is a restoration. So it actually restores, we're seeking restoration of a position that previously was an IT specialist. And at that point, the last salary paid was 84,000. So in this instance, this is one example where we've taken a look at and we're redescribing positions at that time. So redescribing it to a Chief Information Security Officer due to the great need for that position. But to the point of your question, 109 is the bottom of the EM5 level. EM5, which is where this position is classed, ranges from 109 up to 175. So at this point, we're seeking 109. If additional funding is needed or is provided, that would greatly assist us. We do anticipate trying to scramble internally to find additional funds to, as you said, attract a highly qualified candidate. But that's sort of the rationale for the request of this number. But we would greatly appreciate if folks were interested in a higher amount. Okay.
With the department, the old Department of Public Safety turning into corrections and Department of Law Enforcement, traditionally one of the primary objectives or one of the primary purposes of the Sheriff's Department was to provide security at courtrooms. Is the transition going smoothly? Are you getting the coverage that you need? How's that going?
We are continually discussing with the new DLE leadership about the challenges. In recent months, they've been having to pull some of our folks offline, or folks that were assigned to our buildings offline for training or for other, search warrant assignments or other things that has been very challenging for us. It has left some of our buildings less secure than we would like. So we're continuing to have discussions with department leadership about that. And we're hopeful as to going forward.
What are you doing in the interim? I mean, with the sheriffs not in the building, do you replace them with somebody else with a contract security, or what happens?
At this time, no. We do have contract security that we've had before the transition to DLE as well. And the contract security roles are essentially to similar to the state capitol, downstairs working the magnetometers and checking bags. They're unarmed. So that is an area that we're constantly discussing with the new DLE leadership. If it comes to pass that sort of assistance, that extra assistance will be necessary, then that would be, we imagine, as quite a significant cost.
Good.
So we're hoping to work it out with the DLE leadership, so that's not necessary.
All right, thanks. I have CIP questions too, but if you want to let someone else go.
Senator Fatih.
Thank you, Chair. Thank you, Mr. Kimura. I have several questions on table 14 on your active contracts. First is the Carasoft Tech Corporation. That was 1.44 million. It's a 2-year contract. Is there a reason for 2 years, and will that come up every 2 years at that amount?
Let me ask our IT director to join me.
Thank you.
Hi, I'm Maui and then the IT director. This line item actually belongs to CJRI, and it's a service to create a data warehouse for criminal justice data.
Okay. Thank you.
Do you have further questions for the
No, unless someone else has on that topic.
Senator Kim?
I was gonna table 11, one of the vacancies. So I noticed that you have a lot of positions that is defunded. Can you explain all of that?
That's cool.
Yes, those are the remaining of the 192, I believe it was, but just under 200 that were defunded during COVID in the 2020 session.
Okay, so is it intended to go away with those positions, or are we gonna fund it, or what? I mean,
At last session, we saw it and graciously received from you folks restoration of funding for some of the positions. And so we've been working through that this session. We're seeking restoration of 14 more of those. But realizing that we've, with the recruitment challenges, we are doing a number of things. Some of it is redescribing existing vacancies, and so that we can focus and prioritize a chunk at a time.
because you've got some positions like for your court reporters that's been vacant since 2018, 2019.
Yes. Court reporters is one area that has been extraordinarily difficult to recruit. And we've been trying a number of things to help with that. Haven't worked yet, but we're going to keep trying.
Thank you.
Thank you.
Senator DeCoy.
Thank you, Chair. On page 25, table 2, the department-wide totals, overall, the judiciary's budget request is modest. So are all your performance metrics you cite in your budget narrative on page 12 satisfactory or in need of improvement?
I'm sorry, Senator, one more time.
So I'm asking if all your metrics within the request of the budget satisfactory or in need of improvement?
This is in reference to table 12.
Yes.
I'm sorry.
No, table 2, sorry,
Oh,
page
table 2.
25, your overall judiciary budget. And the reason why I'm asking is because earlier you asked for a FTE at 0.5 for social worker in Maui. With all the cases coming down from the wildfire, are those gonna be met?
Our social workers, OPG, have a very heavy caseload, and particularly for the one on Maui, because we only have a 0.5 FTE there now, that's been vacant. So all of our Oahu OPG staff have been trying to cover those cases. We do have other areas of our institution, probation officers, court reporters, other target areas that are very difficult to recruit, that we're working on different strategies. So that in terms of metrics, some of those things are not where we would like them to be, but we're trying different strategies to get them where we can. And OPG is one area I think that's seems like a relatively narrow request, because it's a narrow approach, because clearly we need help with the staffing there. And with just a half FTE, that's not going to cut it. And so that's the reason for our request. Some of the other things that we're doing, such as redescribing positions, we can do internally. But that's an example of something that we believe is a direct request to the legislature, because something we can use help on.
Chair, one more question. And then when do you expect to open a new courtroom at Ho'opili Hale in Wailuku?
That I don't know. I'll have to get back to you on that.
If you can,
I
please.
certainly will.
Thank you.
Thank you, Senator.
Chair.
Senator San Benedicto.
Okay, thank you, thank you. So I want to thank you that it doesn't look like it's part of your budget though, but an administrative request for the increase in court appointed fees. Did I read it right? So it requires us to pass the bills that that judiciary has in order for court appointed counsel and guardian ad litem to have an increase in fees?
Yes, we have as part of our judiciary package bill, not in our budget, but we have as part of our judiciary package, we have a bill that would raise the statutory rates for court appointeds and GALs in family court. And then we have a separate package bill that would raise the court appointed rates in criminal matters. Both of those bills would raise the rates from the current 90 to 150, which is a long overdue increase. I believe on the criminal side, the federal rate is at 164. We're for both the criminal and the family court cases. It's as you know, Senator, difficult to recruit, and it's hard to make it worth someone's time to do that. So
Being a court appointed attorney myself, I mean, yeah, it was very difficult to even do appeals. So I thank you guys for doing that, because it's been over 30 years, since the increase. The second thing is, yesterday in the Department of Health WAM briefings, it kind of reminded me of when the judiciary had a 704 conference in Waikoloa, and the judiciary's request, the Third Circuit Court judiciary's request was for behavioral health center on the Big Island. But what the Kaneohe State Hospital administrator was saying was that when there is a 704 defendant that is transferred to Kaneohe State Hospital awaiting a hearing, but would otherwise be clinically discharged, there is no way for them to offload them. So right now, Kaneohe State Hospital is overbooked. You folks are asking for more rooms. I mean, that's what the 704 conference in Waikoloa said. Is there, I noticed in your budget you had a homelessness request. Is that just for court proceedings, or do you folks have like a potential detention facility? Yesterday, Senator Povella was talking about secured kauhale, so that we can offload those who are awaiting trial, because the Kaneohe State Hospital was saying about 1/3 of the patients there could otherwise be clinically discharged, but are awaiting trial. So is that part of your budget, or is that in some kind of projection for a secured facility for those who are awaiting trial, who are otherwise not available for supervised release or cannot afford bail?
we thank you, Senator, for the question, and thank you for your focus on this area. And so last session, I know one of the measures would have established a crisis hub on the Big Island, didn't pass. We continue to believe that something like that on the Big Island or Oahu would be of great benefit. I know there's a lot of progress on the Oahu portion, on the Oahu facility. We do not run secured facilities or secured kauhale. I understand that DOH and the governor's administration are working on secured kauhale related to mental health, and DOH is working on expanding its bed capacity on Oahu for, potentially shifting folks from the state hospital to other areas. So we don't, the short answer is we do not have it as part of our budget request, but we continue to work with DOH and the governor's administration on potential solutions to this. One of them is the crisis hub. Another is potential areas that it could potential secured beds where we could move folks. We have made significant progress on diversion efforts on Oahu, or standing up a program with partners such as the prosecutor, DOH, and the public defenders. I know we're looking at doing the same on the Big Island.
Do we need a statutory fix to allow for people who are otherwise are not available? And is there a statutory fix for those who are awaiting trial that cannot afford bail, but are otherwise clinically dischargeable awaiting trial for 704? I mean, for otherwise who have asked for 704 defense?
In some sense, I would defer to the Department of Health because those folks are in their custody. But I also know that one of the things that we looked at with them and the Department of the Attorney General and others last session was a particular statute that said that when the person is in custody with mental health challenges or serious mental illness, they are in the custody of the director of the Department of Health. And so that particular statute or that provision appeared to some to say the director could move them from facility to facility. They're in the director's custody. But that's something that, I defer to the Department of Health or Department of the Attorney General.
But something you folks would not oppose, so long as it's some kind of supervised setting that is within the ambit of a pretrial supervision. Okay.
Senator Favel.
Shucks, all these good questions and I changed mine already. It's
Get a shout out.
thank you, yeah, thank you. What is the typical time frame for arrest or conviction? Kind of in the line of what we're talking about, because HPD does their job. They get the people, incarcerate them, and then these guys either getting released for whatever reasons, or overcrowded, or whatever the situation is. So what is the risk? And okay, is that something that you guys are lacking in taking these guys to trial in a timely manner? Because in OCCC, every single time that I take a visit, they have the barracks type facility, and one of the barracks, or two of the barracks, because it's in half, so all guys are waiting for trial. And then some of those guys end up went in there for nonviolent offenses, but then they had to protect themselves, and they did occur a violent offense in there. So I just like, not me, sorry. Other people want to know too, besides me. What is the time frame for that? Because we have a nonviolent people in there that is very small kind charges, but they're waiting for trial. And like Senator said, they can't, afford to get out, but there's no arraignment or no time frame. So is you guys are lacking on something like that, so you can let the committee know, so we know?
Thank you, Senator. I think it varies a lot on the type of charge. One would be circuit court or district court. So if they're in there for a longer period of time, like you said, for months or years, I would imagine that's circuit court, and that's just a lot going on because there's so much at stake for them if they are convicted or if they do plead guilty. So I'd have to get back to you on that. I do know that for district court, which is our lower level offenses, the nonviolent, as you highlighted, the higher volume courts, there too, there are procedural processes that they work through, with their attorney as to whether they decide to plead guilty or not, as the prosecutor's investigating the case. But I believe that in cases where they do go to trial, their trial occurs relatively quickly. And we'll get back to you on the exact, on the average number.
So just the reason why I bring this up is because I work closely, and I've been working with the houses community for years. We get the ones that want to get help. We get the ones that know how to work around the law. So this didn't come from me. This just came from HPD and the numerous of meetings that we have. And we had this under the Weed and Seed program of geographic relocation. So if you're a nuisance in the park and you've been constantly arrested or cited, it was their idea to see if you guys would be against having a jurisdiction restrictions to the park or the area that they keep consistently offend. Because I brought this up to the major and some of the leadership in that area. The question is if you guys would be against that, the jurisdiction restrictions if they get multiple charges in the same area?
I think generally one thing that makes the geographic restrictions very complicated is the breadth and the definition. And part of that is because if they live in the area, if they receive services in the area, if they receive health care in the area.
Living in a park for 8 years, keeping going back and forth in jail, coming out to the same park. What about that?
If it's specific to the
Guy is from Wahiwa. He's not from my community. He's from De La Cruz's community.
I think if it's
Now you know
specific,
where I live.
I think if it's specific to the park, that's probably something we'll definitely take a look at. And I understand where you're coming from. So
Just
thank you,
that,
Senator.
I understand the part about if they live in a community, but
Okay,
those two parts.
okay, we're gonna just take one more question because
Take
we
it.
need,
No.
we need to adjourn by 11:15 for session, and we still need to hear from the Attorney General. And I know many of you have lots and lots of questions for the Attorney General, so Senator Hashimoto.
Real quick, I think, Brandon, what might be helpful is, I think going off of Senator San Buenaventura and Senator Favela, when you add capacity to the courts, right, and an additional judge, it'd be interesting to see what is the subsequent savings that you get from adding that, right? Because I think at some point there's going to be a trickle down effect. If you can get people through the judiciary faster in a more efficient manner, I'll be curious to see what is that, right? Because I think in the hearing yesterday, it was just, we're waiting for a trial, we're all waiting, right? And it would be good to know if it's not even the judiciary, maybe it's not you folks waiting for scheduling, maybe it's other entities, right? But if you can tell us that it's not us that we're waiting and you're at capacity, but I would assume you need more capacity, right, to see these people through. But I'd really want to see that, because if we can quantify that number and if what you're saving from adding positions, I think we'd be probably more willing to add positions just to get that savings, because I think it could be potentially significant.
Thank you for the question, Senator. We'll get back to you on the metrics, but as it raises, we have a clean bill this year and a bill that's carrying over from last session to add a district court judge on Oahu, and that would address the district court folks. In particular, that would make our rural communities more robust. We haven't had an additional district court judge on Oahu since the early 80s, and the community's grown and become more complex since then. So appreciate your consideration on that other package bill of ours. And it's already funded. So,
Okay, we're gonna recess and have the Attorney General. We'll just take 2 minutes. Okay, calling the Joint Committee back to order. Now we'll hear from the Attorney General, who will present their supplemental budget requests. Good morning.
Good morning, Chair Dela Cruz and Chair Rhodes and members of the committees on Ways and Means and Judiciary. I know that we have a hard end date, so I'll try and move through things quickly. First, I'd like to introduce my folks who are here that you may have questions for. Brendan Kinoshita, and I want to thank you for rescheduling the hearing so that he could be present. We all know that with him here, it'll be more smooth. And Matt Devansh, my first deputy, David Day, my special assistant, Tony Schwartz, our new full-time PIO. We also have from Child Support Enforcement Agency, Lynette Lau, Sherry Wang, and Brendan Flores. And from the Crime Prevention and Justice Assistance Division, we have Julia Bato. And from the Hawaii Criminal Justice Data Center, we have Phil Higdon and Susan Yonemura. Attached to our department is the Hawaii Corrections Oversight Commission, and Kristen Johnson is here as well. I thought if I could just briefly do a couple highlights, a couple challenges from the last year, then we can jump into our budget.
Okay.
Okay. First, on highlights, we hired a full-time PIO. That was a discussion we had last year. I was a little, frankly, like, I'm not sure we need one. After the year that we've had, we absolutely do. And I'm glad that we were able to get Tony from Public Safety to come join us. We have been able, well, thanks to the Senate's increase in the appropriation for salaries for our deputies, we've been able to hire 44 deputy attorneys general in the last year.
Now, our number doesn't look like it's increased too much because we've also had 29 deputies leave. 10 have become members of the administration and deputy type of positions or director positions. We've had retirements, and then we've had a number who have moved to other government positions, as well as some who have just left. With respect to our vacancies, they are going to continue. Right now, we have 74 deputies who are 55 or older, and 19 of those already have their 30 years. So I anticipate that every year I'm going to come in and thank you for those raises and tell you what our rolling numbers are. The next highlight is, you're all aware of this. I'm really proud of the work that David Day did taking point on the cannabis bill. He managed a team within our division who worked with our clients externally and with the legislature and other stakeholders to prepare and provide what I think is the most robust and comprehensive cannabis bill in the United States. Challenges, I have two I want to talk about. The first involves the Honolulu prosecutor. In July, Steve Alm informed me that he had unilaterally decided to no longer prosecute any arrests or citations that arose from state law enforcement. That's DoCare, sheriffs, harbors, and airport police. He gave me a date of October 1. We tried to find a solution. He did not want, I don't think, to find a solution. So as of October 1st, my department has taken over all of those cases. Since October 1 to the present, we've taken in over 600 district court cases. It has increased our deputies' time. Obviously, in dealing with those cases, we do not have deputies located at each of the district courts in the state. As a result, we now have people traveling to court as well as going to the Honolulu District Court. Courts have been, Judiciary has been helpful with us in trying to find the best solutions to manage this. Then in December, Steve Alm's staff informed my staff that they would no longer be pursuing bond forfeitures and that they were transferring that over to us. Again, it was a unilateral decision. And he told my staff, he did not tell me. This has increased. We've had 30 referrals for bond forfeiture since December 7th. That has increased the work from our our civil recoveries division. Today, I'm not asking for more resources to cover this extra work, in part because I don't know what those resources are yet. We anticipate spending the next year collecting the data that we need. I anticipate the work to increase, but when I come back, I want to have the numbers for you to establish what we need and why.
Can I just ask the reasons they gave for doing this? The prosecutor's office gave for doing it?
I think it is related to his vacancies, but that was all of the explanation that I received. The second challenge is the Maui wildfires, obviously, from August 8th to and through the present. My entire department has been involved in some way or another with the Maui wildfires. Now I have this under challenges, but I'm also really proud of the work that's been done. Our child support enforcement agency had to sort of just jump out of the box to help families find solutions to issues for people who are unemployed, to make sure those families are taken care of. We have had our investigators looking at charities fraud, unlicensed practice of law, landlord-tenant evictions in violation of the EP. While these have all been challenges, I'm also really quite proud of the work my department has done. To date, we have 69 lawsuits filed against the state related to the Maui wildfires. As you all know, I did decide, along with the governor, that an independent investigation should be completed to find out what in government worked and did not work at the state and county level. What policies and procedures and fire protection measures did we have in place at the time and really determine what worked and what did not. That investigation is ongoing. I anticipate having my phase 1 report out in March. I was hoping to have it done by the end of the year, but I haven't been able to collect the information as quickly as I thought I would be able to. That phase 1 will show what the facts were and what the timeline was and how everything unfolded from August 8th through I think August 11th. The phase 2 will be an analysis of this information and really identify what didn't work, what went wrong in this process, but also what went right. And the final phase, which I hope to have completed by November of this year, will be a kind of a recommendations for best practices as we think about policies and procedures going forward. The Fire Research Safety Institute are the very best at what they do. They know what they're doing. And what I really want is to be able to provide the legislature and the governor with information that can help you shape policy and funding going forward to prevent this from ever happening again. That was my presentation.
Do you want to go into real quick and what do I want to 5 requests?
Actually, I think we have 3.
Oh, some more trade-offs. Yeah,
Oh,
we
okay.
can skip the trade-offs. Go ahead.
Okay, the 3 priorities for us are, as you know, when DLE was stood up, 3 of our positions in our investigations, well, about 21 positions in our investigations division were transferred to DLE. Among those were our chief investigator, deputy investigator, and secretary. We still have an investigations division and need to have an investigations division. So we're asking for those positions and funding for those positions. In the meantime, we've worked with DHERD on a temporary project so that we could put individuals into those spots. The second is adding funds to the FY25 for purposes of the career criminal and victim witness program. That is primarily a pass-through from our department to the counties, although our department does have funds for our own victim witness program. And then finally are the positions and funding for the Hawai'i Corrections Oversight Commission. I'll let Brendan explain those ins and outs. And of course, Kristen is here to answer any questions that you might have.
Okay.
That concludes my
Question.
Okay, why don't we go straight into questions then?
Question.
Senator Rhodes.
Thanks. So as you're aware, there's a suit called, just commonly referred to as the Navahine suit. It's a group of youngsters who are suing the state on
correct.
primarily on Hawaii constitutional claims about the future of the climate and whether they'll have a safe place to live when the time comes. A couple of questions about that. So I understand that it was former Director Butai at the Department of Transportation who was the named party, but they have hired an outside I think a California firm to represent them. Is that a decision that you had to approve? That I mean, normally a lawsuit against DOT would be handled by your office, correct?
That is, well, 2 parts. When we do hire special attorneys, deputy attorneys general, for outside counsel when it's needed, typically in either.
So in this case, that's what you did.
Yes. So let me say that decision was made by the prior administration after going through the facts, the pleadings, and understanding the situation. I think they made the right decision.
Okay, so why? Because I mean, they're Hawaii's constitutional state claims. So you're saying a continental firm knows more about the Hawaii Constitution than your office does?
The issues that are in the complaint have to do with the environment and climate change.
Wait, can I just
And-
call a recess? Yeah, I'm sorry, but we don't allow okay, calling back to order. Go ahead.
I have brought Kira Kahahane up to the table. She is a deputy in our department who's working on this case. And so in the event you have questions I can't answer, she's going to help me out.
Okay. So, I mean, I guess that my back to the original question was, why would we farm out a case like this where the complaint is based on Hawaii constitutional law, which presumably your office is more expert in than anybody else in the world?
I would agree with that part. We did not farm it out. We hired special counsel to assist. Kira's complex litigation division is actively working on this case. But let me tell you why. The claims in the 70-page complaint involve environmental and climate change issues. These are scientific issues that have to do with emissions, with the kinds of programs that we have that impact climate change. Those are things that we are not experts in.
Right, but the Hawaii State Energy Office in December came out with a report saying that Hawaii is not on track to meet its emission limits goals, indicating that much more needs to be done at a faster pace, which, having looked at the 70-page complaint, looks to me is like exactly what the plaintiffs and Navahine are asking for. So even if, what are we trying to get? It looks to me like the best the state can, I wouldn't call it the best. It looks like what the state is trying to do is just put off the day where we have to do the stuff, but we're going to have to do it anyway, because that's what Mother Nature is throwing at us at this point.
Absolutely, that's what we want.
So why are we
want to achieve?
So why are we stalling?
We're not. We have attempted to go into mediation with the plaintiffs. We've had, I think, over 5 days, a total of 4 days of
But there's
mediation.
another request for like $2.25 million in addition to the million or so that's already been put out there.
That's true.
What's that for?
Let me explain.
Okay.
I'm glad you asked that question. When we agreed to do mediation with the plaintiffs, we requested that the plaintiffs put a hold on discovery, meaning requests for documents, interrogatories, depositions, and so forth. We made 2 requests and the plaintiffs refused. It is standard when parties are in litigation to put discovery on hold, because good faith settlement negotiations, we're hoping to settle and not waste resources. They refused. Please let me finish. I'm
Okay,
sorry.
go ahead.
I'm
Go ahead.
passionate about this.
Go ahead.
From July 21st to the present, we have spent $645,000 on outside counsel. Of that, maybe $150,000 covered the mediation. The rest of it was responding to plaintiffs' discovery, preparing our witnesses for 7 depositions, and defending those depositions. We went to mediation. We made a settlement proposal. The plaintiffs rejected it. So the reason I'm passionate is I tried to save resources.
So
the plaintiffs refused.
Okay, so what is the goal then?
Okay, you know what?
I'm sorry.
No,
Okay.
the budget bill is going to go to Judiciary first, and then it's going to come to WAM. So some of these conversations, just so that we don't take up
Okay.
the time for all members to
Let me just ask one last question and I'll be done. So for the 2.25 million, that's not even for this fiscal year. The trial is on June 24th this year. So we're asking for additional over $2 million for after the trial. Do we expect to lose and we're going to have to appeal, or what's the strategy?
I need to say that 2.5 is not coming from my department. I didn't request it. And frankly, wasn't really aware of it until after the budget came out. And Director Sniffen and I can certainly keep talking about that.
Thanks, Chair.
Okay, Senator Kidani, followed by Senator Noy.
Chair, I just had a concern that whether or not we give any state funds to the city prosecutor to do some of the litigation, because if they're throwing it all back to you, I would suggest that we remove that funds from their budget.
Brendan?
Senator, the monies that
Please
I
state your
know,
name.
at least as part of what's in our budget right now. the
State
count-
your name.
Oh, apologies. Brendan Kinashita, Administrative Services Manager for the department. Part of our budget request does include the pass-through monies to the counties for the career criminal prosecution and victim witness. So there is a breakdown. Some of that monies is for Honolulu County. I mean, I'll have to defer to the Attorney General. I do think that those monies in particular, though, those are intended to support, victims and witnesses of crime. The CCC portion is to go after repeat offenders, right? So as far as what we currently provide to the counties in terms of financial support, it's those two programs.
Senator.
Thank you. I'll make it fast. Going back to what you mentioned about city and county relinquishing the cases back to you with regards to several of the agencies. I chair the Committee on Water and Land. So my question is, and I think you highlighted, all DLNR, daycare, harbors, and everything else under the sun. I guess it's related to DLNR. So my question is, does it impact the DLNR's division in itself? Because, we're in session now, and it's good to know if we need to assist the division if they need personnel or the impacts.
Right. I have spoken with Chief Radula and Chair Chang. I'm actually kind of excited. I think that there historically, Honolulu prosecutors have not taken the daycare crimes and put those as a priority. I think now we can. And I've spoken with the chief. He has spoken with our criminal justice division so that we can start working collaboratively to make sure that their citations, for instance, the most recent one is the guy who took people out paddling without permits.
Right.
So we will be prosecuting that case.
Okay.
And
So
we'll work
anyway,
closely.
yeah, my concern was if it impacts anything that has to do with the division, and I guess I'll hear from them as well.
Senator Gabbard, followed by
And
Senator
then
Kim.
if you can respond, are we going to get reimbursed from for the work that the investigators have with the wildfire on Maui?
Yes, and thank you for the preview of the question, Senator.
Yes.
So those investigators, the reimbursement through FEMA is being conducted via then PSD, now DLE, because they made the request to the department to provide those investigators for the mayor's detail. And we have a MOU with them that they were funding for those investigators anyway. So we've been reimbursed from the department. And so they're seeking the FEMA reimbursement for their budget.
Okay, thank you very much.
Senator Gabbard.
Two quick questions about the Nabahini case. Does the AG's office retain oversight or involvement in the case when outside counsel is used?
Absolutely.
And the second one is, who decides what strategy is used in the lawsuit involving outside counsel?
Me.
Thank you, Chief.
Senator Kim.
This is an issue. I was talking about table vacancies that I have talked about time and time again, and I
Table
understand
11.
the need for 89-day hires, but the use of 89-day hires has really been abused in the AG's office. I mean, you have 79 appointments, 57 appointments, 40 appointments for 89-day hires, and 89-day hires, as you well know, is supposed to be for emergency hires. And I know there's difficulty in hiring investigators and stuff, but come on, 79, that's what, 20 years?
Well, I'm very excited to say that we now only have a total of 13 89-day hires, and that would be 9 of the investigators. And I think now in our department, the longest open position has been since 2019. If I had my druthers, we would create a full-time, non-benefit earning position. The 89-day hires with respect to investigators exist because we are able to get retired police officers, which means we don't have to provide firearm training or investigatory training. So that is, if we can get that, we would be able to hire those folks on a full-time basis and stop the 89-day hire nonsense.
Okay, so are you working on that?
Give us language for a bill.
Yeah.
Pardon me?
Give us language for a bill.
Okay, we will.
Yeah, today's the deadline, so you better.
Senator Lee.
Thanks. I just want to follow up on Chair Rhodes and Senator Gabbard's question. The 2.25 million, you said you weren't, it's not in your budget request. It's in transportation.
I believe transportation is making the request,
You
yes.
didn't know about that till right now?
No, not right now. I mean, when the budget dropped and people started asking the question, I did.
So how how did they know how much to ask for? Because if you're the one deciding to use outside counsel and what they're going to need and all of that, is the department just throwing money in the budget for the sake of throwing money in the budget?
Well, I disagree with that characterization, Senator. We are not doing that. Ed Sniffen, the Director Sniffen, has been absolutely actively involved with our attorneys throughout this process. He speaks with them regularly, and it is more likely that he's going to be asking those departmental questions because those funds impact his department. So I think it makes perfect sense for him to have had those conversations and make that decision.
So thanks, Chair. And there's a couple concerns here, I think, but separate from the merits of the case itself, on the climate side, we started looking into this a couple days ago because everybody dropped by on opening day. But so much of the progress the state makes, collectively we make on various issues is because we set goals and direction for departments to execute, whether it's affordable housing units that we want to build by such and such date, or doubling local food production by 2030, or improving educational outcomes. All these things, including climate goals, of course, all these things happen because we push the departments to move. But reading through the court filings themselves, there's a concern that basically what's being argued, you're arguing, is that departments don't have to act on those goals and directions set by the legislature in so many cases, and the courts can't force them to, which in oral arguments especially, the case was made that they don't even have to lift a finger until the actual date that the legislature said they're supposed to achieve these goals. So, for example, Department of Ag wouldn't have to double local food production or take any steps on it until that date arrives. So it's a bit concerning because ultimately this undermines the legislature's authority to compel departments to do really anything. And you're asking, well, not you, but I guess the administration is asking for funds to make this case, which could completely undermine our own authority here in the legislature.
Hang on just one moment. So the only oral argument we've had thus far is with the motion to dismiss the case, which was denied. So there hasn't been any oral argument on it yet. Let me say with this case, if I were to not defend it or to just say, okay, then we, the state, and my office would be admitting to the truth of the allegations in the complaint, which I simply cannot do across the board. The second part is the plaintiffs are asking for a special master to be appointed by the court. And that one person from the judiciary would then be responsible for determining the goals, priorities, and funding for all state activities that involve climate change, not just the DOT, the whole state. That means the judiciary, in my mind, would be stepping into the shoes of the legislature, making decisions that belong to you in collaboration with the executive branch. And I can't just agree to that outright.
Chair, maybe we can follow this up in the judiciary hearing that you referenced, but let me just follow up by saying that I'm reading verbatim here, quoting the filing. As defendants elsewhere explain, the requirements of these laws, e.g. endeavor or meet goals as soon as possible, are not rules or standards the court can apply. I think the concern is not what you're saying, but rather the legislature's opined on so many different issues and in so many different departments that they should be doing things or achieving goals. And we're not going to prescribe the step after step after step for how they should do that.
I think we have to, though.
They should move.
But
I think we have to.
And so I think the key is we don't want to lose that legislative intent and authority and let departments off the hook when you have things like this that could set a precedent that would do just that.
I agree with that. I have also brought enough to pass out, if you want me to do it right now, the state climate action fact sheet that provides what the Department of Transportation, the State Energy Office, the Public Utilities Commission, the Hawaii Climate Change Commission, and the DLNR are doing to combat climate change consistent with the legislature. I have those fact sheets, and if you like, we can pass them out right now.
Well, we're going to end the meeting soon, and so you can, if there's no other questions, okay, I'm going to adjourn. However, I'd like the Attorney General and some of her key staff to remain, and then if we can ask everybody to leave. Okay, adjourn.